Welcome back, dear students. Today, from Unit 4, we will cover and learn how to draft a lease deed, and this will be 25th lecture from Unit 4. Dear students, we have discussed earlier also the references and the books which you can pick up for drafting of a lease deed, which is also known as a rent deed. We have a very good book written by Mr. R.N. Chaturvedi on conveyancing, published by Eastern Book Company. Then we have another book written by Mr. G.C. Monga, Law of Pleadings in India. Then third book available in our library is written by C.R. Datta and M.N. Das. Next one written by Mr. K.K. Shrivastava on Law of Pleadings, Drafting and Conveyancing. This book is published by Central Law Agency. Its second edition was published in 1982. Then we have another book written by Mr. S.R. Maineni. Its heading is Drafting, Pleading and Conveyancing, published by Asia Law House. Its reprint edition was published in 2017. So you can pick up any one of these books so far as the drafting of a lease deed is concerned. Now, dear students, before you start drafting of a lease between landlord and tenant, you must know what is a lease. Because in the absence of this conceptual clarity, your drafting is bound to be misplaced. And then you are likely to lose the case as an advocate if your drafting is not proper, if your drafting is not in accordance with law, and if your drafting is against the provisions of Transfer of Property Act, which define the term lease and how to determine the lease. So, dear student, a lease of immovable property is actually a transfer of right to enjoy such property. It's not transfer of property. It is only right to enjoy such property in consideration of a price paid or promised, or of money, that is rent, or a share of a crop in cases of lease of agricultural land, or services, or any other thing of value to be rendered periodically. Say if it is a case of monthly rent, then rent has to be paid monthly. If it is a case of agricultural land or land for manufacturing purposes, then rent may be payable 6 monthly or even annually. Or there may be another mode of payment of rent on specified occasions, like Diwali to Diwali. Who will pay this rent? Rent is to be paid by the transferee to the transferor who accepts the transfer on such terms. This is the definition of a lease in accordance with Section 105 of TP Act. So basically, dear students, if you look at the back of this lease deed, you will find that there is an oral agreement behind it. Because first of all, the terms and conditions are settled between landlord and tenant orally. The tenant will come and will have a look at the accommodation. Then he wants certain improvements to be done by the landlord. Then landlord will fix the rate of rent orally by their mutual agreement. Mode of payment shall be fixed orally. And how to determine this lease will also be decided between the parties. How much will be the duration of the lease is to be decided by the parties. So dear students, we have seen in the last lecture also that whenever you draft any deed, any document, it has an oral agreement at the back of it. And this lease deed is nothing but a memorandum of what was orally agreed between the parties in accordance with law. So please keep in mind that lease of immovable property is not a transfer of property. Transfer of property can be done by sale deed, by gift deed, but not by lease deed. So what is a lease? A lease of immovable property is a transfer of right to enjoy such property in consideration of a price paid or promised, or of money, that is rent, or a share of crop. You must have heard in the rural areas, in villages, that a person who cannot do the agriculture business himself, he gives his land to another person on lease, and the agriculture produce are divided equally between them. So that is a share of crop, maybe 50-50, maybe 75-20, or share of services or any other thing of value to be rendered periodically. It may be monthly, it may be 6 monthly or annually, or it may be on specified occasions like Diwali to Diwali, and it is payable to the transferor by the transferee who accepts the transfer on such terms. So dear students, you must keep clear-cut idea about what is lease before you start drafting a lease deed. Now the person who is transferring, the transferor, he is known as lessor, and the transferee, that is the tenant, is called as lessee. And the price or the rent, which is mutually agreed, is known as premium. And the money, share, services or other thing to be so rendered is called the rent. Rent and premium. Premium may be something other than rent. You must have heard that somebody has taken a shop on rent in some mall, and he is paying 1 lakh rupees per month rent, but he has paid 25 lakh rupees premium also, commonly known as pagdi. In Hindi, it is known as pagdi. So premium and rent are different. You see, Transfer of Property Act deals with all these concepts. And this Transfer of Property Act was amended by TP Amendment Act 2003 with effect from 1st March 2003. And new section 106 was substituted in the Act. Previous to that, the notice terminating the tenancy of the tenant to be given either by the landlord or by the tenant should expire with the end of a year of the tenancy in case of yearly tenancies, and in case of month-to-month tenancies, this notice terminating the tenancy should expire at the end of the month of the tenancy, meaning thereby that this notice should be given in such a way that the notice expires with the last day of the month, that is 30th or 31st. And in first case, notice should expire with the end of the year, that is 31st December or Diwali to Diwali. But this is slightly difficult in practice. It was felt in practice that it is difficult to calculate the sending of the notice in such a manner that the period of 6 months in case of agricultural land and period of 15 days in case of monthly tenancy expires on the end of the year, that is last day of the year, and in case of monthly tenancy the notice expires on the last day of the month. It was really difficult because sometimes the post office takes 2 days in delivery of this notice. Sometimes it is delayed by 7 days also. And if there are some holidays in between, then post office may take more time for delivery of this notice, because that period of 6 months or period of 15 days is to be calculated from the date of receipt of the notice. It is not the date of issue of the notice. It is the date of receipt of the notice by other party, that the tenant remains a valid tenant up to 6 months more after receipt of the notice in case of agricultural land, and the tenant remains a valid tenant for 15 days more after receipt of this notice. So that is an exemption period available with the tenant, so that he may search other options for his living. Now you are going to draft a lease deed. You should have a knowledge about the duration of the lease deed which you are going to draft. Maybe that parties have mutually agreed to certain duration, then that duration will prevail. Or if there is some local law or usage to the contrary, then that local law or usage will also prevail. But in the absence of any contract between the parties, in the absence of any local law or usage to the contrary, what is the duration of a lease? A lease of immovable property for agriculture or manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either the lessor or the lessee by 6 months notice. Previous legal position was that this 6 months notice expiring with the end of the year of the tenancy. Now this portion written in the red has been amended, and it is not required that this 6 months notice should expire on 31st December, that is end of the year of the tenancy. So now the legal position is that if you have given your agricultural land on lease for agricultural purposes or for manufacturing purposes, so duration of the lease shall be from year to year, terminable on the part of either lessor or lessee by 6 months notice. B, if it is a lease of immovable property for any other purpose apart from agriculture and manufacturing purpose, then the duration of the lease shall be deemed to be from month to month, terminable on the part of either lessor or lessee by 15 days notice. Previous position was that this 15 days notice expiring with the end of a month of the tenancy. End of the month means either 30th or 31st. But this, again, the portion shown in the red has been deleted, and now notice may not necessarily end on the last day of the month of the tenancy. As I told you, that this period of 6 months or 15 days is a grace period for the tenant. He remains a valid tenant even if he has received the notice of termination of tenancy. In case of agricultural land, in case of land given for manufacturing purposes, the tenant remains a valid tenant for 6 months even after receiving the notice, because this 6 months period is given to the tenant to cut his crops, to wind up the business. And similarly, month to month tenancy, which can be terminated by 15 days notice, this period of 15 days shall be counted from the date of receipt of the notice. Date of issue is not important. It is the date of receipt of the notice from where the period of 15 days will be counted, and the tenant remains a valid tenant for this grace period of 15 days also. After 15 days, his tenancy stands terminated. But sending of the notice, the receipt of the notice. After receipt of the notice, tenant remains a valid tenant for 15 days more, and then his tenancy stands terminated. So this calculation you must know because you are going to draft a lease deed today. Now this notice of termination of tenancy, which is given under section 106 of the TP Act, this notice can be given either by the lessor or the landlord or by the lessee, who is also known as tenant. This notice under section 106 TP Act, which is to be given a 6 months notice in case of agriculture land or a land given for manufacturing purposes, and this notice period is 15 days for monthly tenancy for any other purpose. This notice also we will learn how to draft it in the coming lectures, but this notice must be in writing and signed by or on behalf of the person giving it. You cannot orally terminate the tenancy of a tenant, or tenant cannot give a notice terminating his tenancy, quitting the accommodation orally. This has to be done in writing, and it should be signed by the tenant or on behalf of the person. On behalf of the tenant, his counsel, his advocate can sign this notice. And this notice must be sent by post or tendered or delivered personally to the party or to one of his family members or servants at his residence. Or alternatively, if such tender or delivery is not possible, then by affixing the notice at some conspicuous part of the property under tenancy. You paste the notice on the main gate of the accommodation. It is also a valid service of notice. Now, dear students, since you are going to become advocates and you are going to draft many lease deeds during your practice days, and you will come across your client, maybe landlord or maybe tenant, and he may request you to draft a notice to quit on behalf of the landlord, terminating the tenancy of the tenant. At this juncture, dear students, the calculation of the term of the lease is important. The first rule is exclusion of the day on which the term of lease commences. The day when this agreement, the day when this lease deed is signed, the beginning date or commencing date of the tenancy has to be excluded while calculating the term of the lease. Say, for example, A, where the time limited by lease of an immovable property is expressed as commencing from a particular day, then in computing the total term of the lease, that first day shall be excluded. For example, if lease is to begin from 1st January 2020, then this first day of January shall be excluded while calculating the total period of lease. This is in accordance with section 110 of Transfer of Property Act. And where no day of commencement of tenancy is named, the time so limited or the duration of the lease begins from the making of the lease. It is also in accordance with section 110 of Transfer of Property Act. Now, how to calculate the term of the lease for a year? If it is a case of yearly tenancy, how to calculate the term of the lease? See where the time so limited is a year or number of years. Then, in the absence of an express agreement to the contrary, lease shall last during whole of the anniversary from the day from which such time commences. Yearly tenancies, in the absence of express agreement, will be valid for whole of the anniversary. Anniversary means 1 year. Suppose a lease for 1 year with effect from 1st January 2020 will commence excluding the first date of January. It shall be commencing legally from 2nd January 2020 to 1st October 2021. No, it should be, no. Lease for 1 year with effect from 1/1/2020 will commence from 2nd January 2020 and it will last up to 1st January 2021. So this second, counting from 2nd January, ending the period at 1st January 2021 is one anniversary. This is how the lease term is calculated if it is a case of yearly lease. Now we must know how a lease is determined, how to terminate the lease. Determination of lease. When a notice of termination of the lease is given, the period of notice, it is 6 months in case of agricultural land and land given for manufacturing purposes and 15 days in other cases of monthly tenancy. Now this notice period, 6 months or 15 days, shall be counted from the date of receipt of the notice. As I told you earlier also, that date of issue or date of signing the notice is not material. That date is material when the tenant has received this notice actually. And lease remains valid until expiration of the notice. The tenant remains a valid tenant for this grace period of 6 months or 15 days. And the lease will be determined on the expiration of this notice period. That is 6 months or 15 days. Lease shall be determined. Tenant will quit the property leased on expiration of the notice period. So he remains a valid tenant for 6 months or for 15 days as the case may be. After service of notice, I told you, the tenant remains a valid tenant for further 15 days or 6 months as the case may be. Now let us see how to determine a month-to-month lease and how it is to be calculated. As a lawyer, you must know this determination of month-to-month lease has to take place in accordance with section 111H of Transfer of Property Act. Suppose the lease was for 11 months only on month-to-month basis and the lease started from 1st January 2020. A notice dated 1st April 20 was given by the lessor to the lessee, and this notice was received by the lessee on 5th April 2020. Within 4 days, he got this notice. Now the period of 15 days will be counted from 5th April, not from 1st April. And the lessee will remain a valid lessee up to 19th April 2020. And his tenancy will stand terminated with effect from 20th April 2020. And it is not necessary now that monthly lease should terminate with the date of ending of the month. So now, in this case, the tenancy will stand terminated with effect from 20th April 2020 and up to 19th April, the tenant remains a valid tenant. Now let us see how to determine a yearly lease. Suppose yearly lease was given for agriculture or manufacturing purposes for 10 years on 1st January 2010. Now how to calculate this period of 10 years? Very simple. The period of lease will start with effect from 2nd January because the date of the lease has to be excluded. So it begins from 2nd January 2010 and period of 10 years will expire on 1st January 2020. Very simple. The first day is to be excluded. Now, if a notice of termination of this yearly lease is given by the lessee to the lessor, on 1st January 2019. And the notice is received by the lessor on 7th January 2019. So this lease will continue with effect from date of receipt of the notice, that is 7th January 2019, plus 6 months more, up to 6 June 2019. This period is not ending with the end of the year, and it is not necessary now that lease should terminate with the end of the year. Now, dear students, with this background, we start drafting of an actual lease deed. And I may tell you that this lease deed which you are going to draft should be drafted like a bilateral deed, in which the landlord and tenant both will put their signatures on the lease deed. And there should be 1 or 2 witnesses also, in whose presence the lease deed was written. This lease deed is also known as the rent deed. In Hindi, it is known as Kirayanama. In English, it is known as rent note, rent deed, or lease deed. So first of all, the beginning of the lease deed is to be made by describing the complete details of landlord as well as tenant. So we will begin like this, that this lease deed is made at Delhi place on this first day of January 2017 between A, son of B, resident of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP, hereinafter called as landlord, first party of the first part. So first party to this lease deed is the landlord, and this lease deed is made at New Delhi, and the date of deed is 1st January 2017. And the second party is X, son of Y, resident of 52 Lajpat Nagar, New Delhi, hereinafter called as the tenant, the party of the second part. So first party is landlord and second party is tenant. We saw this concept while drafting sale deed also, that the expression landlord and tenant. In sale deed, the expressions seller and purchaser, their meaning included their respective legal heirs, executors, representatives, nominees, and assignees respectively. Here also, unless repugnant to the context, the expression both the parties, that is landlord as well as tenant, lessor as well as lessee, shall mean and include their respective legal heirs. Suppose if the landlord dies, then this rent deed is binding on his legal heirs. It is binding on his executors, representatives, his nominees, and assignees. Suppose after entering into this lease deed, the landlord sells the property to someone else. Then this lease deed shall be binding on the purchaser of the house also, because tenant is already sitting there as tenant. Likewise, if the tenant dies after execution of lease deed, then the terms of the lease are binding on his legal heirs. If tenant dies, then deed is binding on their sons, daughters, and wife. So word tenant also includes, word lessee also includes their respective heirs, executors, representatives, nominee, and assigns respectively. Now, the next part of the drafting begins with the word whereas. This we have seen while drafting sale deed also. Whereas the first party is the owner of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. Yes, first party is the owner of the property which is going to be leased out. And whereas I told you that behind every deed, in the background there is an oral agreement. So you have to draft this paragraph like this, that whereas the second party, means tenant, has approached the first party, landlord, to take on rent a portion consisting of one bedroom, one dining room set in the above said property, hereinafter called the said premises, and the first party has agreed to let out the said premises to the second party on a monthly rent of rupees 30,000 only for a period of 11 months, starting with effect from 1st January 2017 and ending on 30th November 2017. This is the period of 11 months. And the second party has also deposited a sum of rupees 60,000 by check number 34987 dated 1/1/2017 drawn on HDFC Bank, Vikas Marg, Delhi 92, in advance with the first party towards the security amount, which shall be refunded by the first party without any interest at the time of the vacation of the above said premises. So this is the general terms and conditions which you will see in all the rent deeds, that monthly rent is fixed and 2 months rent is taken by the landlord as security for the premises, and this security amount is refundable without interest to the tenant when the accommodation is vacated. Now the following terms and conditions have been settled between the above said parties, witnessed as under. I told you that behind every written document, behind every written deed, there is an oral agreement in which the terms and conditions are settled between the parties. So, terms and conditions number 1 is that the settled rent neither shall be reduced nor shall be enhanced by either party during the settled period. The property is given at the rate of rupees 30,000 per month for 11 months. So during period of 11 months, the rent will remain 30,000. It shall neither be reduced nor shall be enhanced by either party during the settlement period, that is a period of 11 months. Number 2, that the said monthly rent shall be payable on or before 7th day of each English calendar month in advance. This, usually you will find this clause in all the rent deeds, that the monthly rent shall be payable on or before 7th day of each English calendar month in advance. So rent is to be paid by 7th every month in advance. Now the next condition agreed is that the bills of electricity and water supply shall be payable by the second party, that is tenant, but the house tax of the said premises shall be payable by the first party. This is very usual and customary to write down in all the lease deeds, that electricity charges and water supply charges will be borne by the tenant because he is consuming electricity and water. But so far as the house tax is concerned, it is payable to the government or municipal authorities. That house tax has to be paid by landlord, that is the first party. Another point agreed between the parties was, para 4, that the above said premises shall be used by the second party only for the residential purposes. Yes, this accommodation cannot be used for commercial purposes. If you are drafting a lease of a house or plot of land for commercial purposes, then drafting will be slightly different. Here you are drafting a lease deed given by the landlord in favor of tenant on a monthly basis for 11 months for residential purposes only. So above said premises shall be used by the second party only for the residential purposes and shall not be used for any other purposes if he or she shall do so. If he changes the purpose, then he shall be liable for immediate ejectment from the said premises without any prior notice in this regard. If you change the purpose from residential to commercial, you are liable to be ejected immediately without any prior notice. This is agreed between the parties. And dear students, it's not the landlord alone who can terminate the lease. Tenant also has a right to leave the accommodation after giving a due notice for 15 days. So para 5 is that either party can terminate this rent deed either with 1 month's notice in advance or with 1 month's rent in lieu thereof. This was the condition agreed between the parties, that either the landlord or the tenant, they are at liberty to terminate this rent deed. So 1 month notice is required in advance or with 1 month's rent in lieu thereof. If landlord wants to terminate the tenancy, he will have to give notice. If tenant wants to terminate his own tenancy, then he will also have to give the notice. Now you see, tenant is residing in your premises as tenant, monthly rent is fixed, but the landlord or his workmen or his representatives may need to enter the house for the purposes of inspection or repair. And then tenant says, no, it is my privacy, I will not allow the landlord or his workmen to enter into the tenanted accommodation. No, this is agreed in advance, and para 6 is to be drafted like this, that the first party and his representatives, surveyors and workmen shall have the right to enter into the premises at all reasonable times for the purpose of inspection of the said premises or for the purposes of repairs. So tenant will allow the entry of landlord and his workmen for the purposes of inspection of the tenanted premises and its necessary repairs. And the second party shall abide by the bylaws, rules and regulations of DDA, MCD or Delhi Vidyut Board and other local authorities concerned. If the property is situated in UP, then of course the regulation and bylaws of municipal corporation will be binding on second party. Now dear students, this house is given on rent of rupees 30,000 to the tenant alone. He cannot sublet it. Subletting is prohibited if agreed between the parties. So this you will have to draft as a paragraph like para 8, that the second party shall not sublet the said premises under his or her tenancy, and if he or she shall do so, then he or she shall be liable for ejectment from the said premises immediately without any prior notice in this regard. Subletting is prohibited and agreed between the parties. Suppose the tenant has taken this accommodation on rent at the rate of 30,000 and he sublets this property at monthly rent of 40,000 and starts earning 10,000 rupees per month. So if agreed between the parties, subletting is prohibited. So para 8, you have to draft that second party will have no right of subletting the tenanted accommodation. Then comes the question of security amount. 2 months rent in advance, the tenant has given a check of 60,000 rupees to the landlord. Now what will happen of this 60,000 when the tenant leaves the accommodation? So you have to draft one paragraph on this also, that the said security amount which is deposited by second party with the first party shall be returned back by the first party to the second party without any interest thereon. Yes, parties have agreed that no interest shall be payable, but after adjustment of outstanding dues, if any. Suppose 1 month rent was to be paid at the time when the tenant was leaving the accommodation. So out of 60,000, landlord will retain 30,000 because outstanding 1 month rent is there. So after adjustment of outstanding dues, if any, towards the second party, this security shall be refunded to him at the time of vacation of the said premises. Then you are a tenant. You are not authorized to make any additions or alterations without the written consent of the landlord. On this also you will have to draft one paragraph, that the second party, tenant, shall not make any additions or alterations in the said premises under his or her tenancy without written permission from the first party, that is landlord. And if the second party shall do so, then this rent deed shall stand cancelled automatically, and the second party shall be bound to vacate the said premises immediately. Tenant has no right to make additions or alterations in the tenanted accommodation. He can do so with the written consent of the landlord. And if he is doing it without any consent of the landlord, without written consent of the landlord, then of course he is liable to be ejected from the tenanted accommodation because he has not taken the permission of the landlord and he has made certain additions or alterations in the tenanted accommodation. Now what will happen after 11 months? This rent deed you have drafted is only for 11 months. If the parties want to continue the lease deed for another 11 months, what will happen? How will you settle the terms and conditions right now in this lease deed itself? You will have to draft it like this, that after expiry of the settled period, if both the parties mutually agree to extend this rent deed for any further period, then a fresh rent deed shall be executed between the parties on fresh terms and conditions. And if the first party will not agree to give said premises on rent for any further period, then of course the second party shall be bound to vacate the said premises and deliver the actual physical and vacant possession of the said premises to the first party immediately without any prior notice in this regard. And if the second party does not vacate the tenanted premises, then the first party shall be entitled to get the said premises vacated from the second party through court of law. And in event of court proceedings, all the expenses of the first party shall be payable by the second party. So this is the factual and legal position, that if lease was originally for 11 months and there is no fresh agreement between the parties, so tenant is bound to vacate the premises on expiry of 11 months. If he fails to do so, the landlord has a right to get him vacated through court of law, because his tenancy already stands terminated on expiry of 11 months. Or they may agree to extend this agreement by way of a fresh lease deed for another 11 months. That is a different issue. But if they do not agree, on the expiry of 11 months, the tenant is bound to vacate the tenanted accommodation, failing which the landlord has a right to file a suit for ejectment against him at the cost and responsibility of the tenant itself. Then, dear students, we have seen that two witnesses are also required who will sign this lease deed, and the landlord and tenant will put their signatures on this on this deed in the presence of two witnesses. And two witnesses will sign in the presence of each other. And this has to be given a shape, it has to be drafted, in witness whereof the above said parties have put their